Donald Trump is going to be declining to remove his case to federal court. And we followed some other co-defendants in Big Fani's RICO prosecution who have made this attempt, like Mark Meadows, Trump's former chief of staff. And he had a difficult time with this. His case is back down in Big Fani's court. And we're going to see why Trump may have decided to stay here as well. It is a very short declination filing we'll read through. Then we'll explore some of the possibilities as to why he may want to remain in state court. But then he also filed in a different jurisdiction requests for more time. In Washington, D.C., in the January 6th prosecution, Trump has been ordered to prepare for trial and to read multiple Washington monuments worth of evidence prior to the trial because the judge, Chutkan, who has failed to recuse herself, she decided she was doing a great job and is going to stay on the case for a while. She said that it was highly organized and that prosecutor Molly Gaston did a great job with her highlighters. Trump's people say, not good enough, okay? We need more time. We can't read 10 Washington monuments worth of copy paper in 6 months. Give us some more time. There's 2 filings on that we'll take a look at. But the quick one, easy, is the immediate filing from Trump's lawyers. Look how short this is. Stephen Sado filing this in Big Fani's Fulton County, state of Georgia, versus Donald Trump. They say President Trump's updated notice about removal of his prosecution to federal court. We were thinking he would want to remove to federal court, right? We're kind of in like amateur hour land here in Fannyville, and nobody knows really what they're doing. It's kind of a free-for-all RICO case. Trump wants maybe federal immunity. Trump wants, maybe executive sort of privileges that he might enjoy up in the federal district that he's not going to get at the state level. So this comes as a surprise. They say on September 7th, Trump's lawyer, in an abundance of caution, Trump notified the court that he may seek removal of his prosecution to federal court, and that his notice of removal would need to be filed in federal court on or before September 29th, 2023. Well, that's today. President Trump now notifies the court that he will not be seeking to remove his case to federal court. What? This decision is based on his well-founded confidence that this honorable court intends to fully and completely protect his constitutional right to a fair trial and guarantee him due process of law throughout the prosecution of his case in the Superior Court in Fulton County, Georgia, where Big Fanny and the judge reside. Respectfully submitted, Steve Sado. That's it. That's the whole thing. Making sure the court is aware of it, copying all the parties, and that's it. So we're thinking, well, that's curious. I wonder what the heck is going on this one. And so we've got a couple things that I jotted down that might be possible. One, obviously, Donald Trump probably does not want to testify at the removal hearing. So when Mark Meadows was trying to remove his case, he needed to testify so that he could talk about his role, and so that his role would articulate that he was operating within the confines of a federal officer, a federal official. Operation justified the removal, right? So he's got to explain to the court why it needs to be removed. Trump definitely does not want to testify right now. If he testifies right now, he's kind of fair game for a lot of stuff, and he may not want to testify at all, as is his right. But in order to have I would say a higher chance of success at federal removal, he would need to testify. Mark Meadows did it. Mark Meadows didn't win. Trump is a different category. Okay, he is actually the president, and so I think kind of a lot of the things that he does are totally within the confines of that role. But for whatever reason, he's not going to make the decision to do that. So one reason might be doesn't want to testify. Number 2, judges, right? Now I've read that the federal court judge who's assigned to this case is an Obama-appointed judge. Obviously, more experience, been around for a lot longer. In Georgia, we've got a new judge, Judge McAfee, right? Young, 34, 35 years old, right? Fresh on the bench. And there's also some talk that maybe he is actually a little bit more conservative. Like maybe he's got connections with the Federalist Society or something like that. If you think the Federalist Society is favorable to Trump, or let's say wants Trump to win again, I have a different opinion on that. But generally speaking, maybe it's a choice of judge. They like the state judge better for tactical reasons. Maybe they think the judge is, less experienced and they can take advantage of that. Maybe they think the judge is more politically favorable and that's beneficial to them, or whatever reason. Maybe they just want to avoid the federal court judge because it was Obama appointed. Could be a possibility. Another possibility that we talked about this morning on our members only morning stream is about the appellate path. And if Trump loses anything, first of all, what is he losing? What would the downside be? What is he trying to fight and then lose? What is the issue at stake? And does the issue that they're fighting over, does it originate from state law versus does it originate from federal law? And so if they're at the state level, they might say that the current laws here are more favorable to us so that if we lose in Georgia, we'll appeal to the Georgia Court of Appeals and then to the Georgia State Supreme Court and then maybe to the United States Supreme Court. So work their way up from within the state to the Supreme Court rather than take themselves out of the state and go through the federal courts. And one reason they might want to do that is because in federal courts, in my opinion, things are a little bit more professional, right? Things are a little bit more dialed in. Stakes are generally a little bit higher. The level is just a little bit more, it's like, from going from college to the pros a little bit. It's not quite that dramatic. It's like maybe from regular season to the playoffs or something like that is a better analogy. But the point is, it's a little bit higher games, the stakes are a little higher and it's a little bit more dialed in. So if that is the case, the federal judge may be somebody who is correcting some of the problems, identifying them and correcting them as the case is progressing. Whereas if you're at the state level court, kind of a circus down there and you just kind of let the whole thing go. And we know it's kind of a circus because their justice system is pretty broken, right? People are dropping dead in Big Fani's jail. It's kind of a mess there, right? The whole county is kind of a problem. So they might want to operate in that space because it's a little bit more chaotic, a little bit more unknowns that might pop up, and you can exploit those unknowns. Greater propensity for mistakes, greater propensity for chaos, and that's exactly how Trump likes to operate. And lastly, one final reason, TV, maybe they want TV. And somebody brought this up on Locals this morning, shout out, who said maybe Trump just wants a spectacle. In federal court, he does not get to have TV as it stands. So his Florida case, not going to be on TV, presumably. His January 6th case, not going to be on TV. I'll be surprised if his New York case even goes if they get convictions on the other federal cases. And so maybe he wants to go, let's do it. You want to talk about fraud in Georgia? You want to talk about broken water mains that are popping off in the middle of 2 a.m. conveniently on election night? That's weird. Why did a water main break right as we're counting votes? Strange. What a coincidence. So maybe he wants to bring in these conversations and talk about it and present it to the American people and get the full exposure of the truth. So it could be any one of those things, could be reasons we haven't thought about, but the point is Trump is not going to be removing his case. So we're going to be sticking around in Big Fani's court for some time, and we're probably going to see this trial on TV. Hey-yo, which is good news. I think that they were thinking that this would be bad for Trump. Let's see it. Let's see Big Fani out there. If she even does this, okay? If she even prosecutes this case, she'll probably have somebody else do it. All right, we'll see. Now, we'll see if she's in trial for Sidney Powell or Kenneth Chesebro. I tend to doubt it. But in other jurisdictions, Donald Trump is asking for more time because there are 10 Washington monuments. That I know is accurate. Multiple Washington monuments full of documents that they are supposed to read. And Trump is saying, we need more time to process everything, and we need more time. Judge Chutkan, who has failed to recuse herself out of the District of Columbia, they say, we need more time. We need an extension. This is from Trump's people to file pre-trial motions. Now, if I could predict the future, I'm going to guess the judge is going to say no. Why? Because it's Judge Chutkan. They're asking for 60 days. Let's see. Although this is just a pre-trial motions deadline, so she might bump this back a little bit. Let's see. Let's see what their argument is. They say here, we've got a current motions deadline coming up, like October 9th. Can we please postpone that 60 days from now to December 8th? And it's just a pre-trial motions deadline, Judge, so it's like not trial, not anything major. We just need more time to investigate. Here's why. As you know, this case presents numerous novel and complex legal issues. I'm not even sure the judge would agree with that, though. Counsel has been diligently researching these questions and preparing the appropriate pretrial motions, since we've never indicted a former president, current presidential candidate before, and tried to gag him and then cram a trial down America's gullet in a matter of months. But this requires a brief extension of time, Judge, just to complete the process. For the reasons below, Trump seeks the requested extension to ensure that he can raise all the relevant legal issues consistent with his Fifth Amendment right to a fair trial and to present a full defense. The prosecution has already advised that Jack Smith objects. He opposes our requests. Typical. Trump's defense says, Your Honor, this case is the first of its kind, and it concerns many legal questions of first impression. This is the first time in history anyone, let alone a president of the United States, has been charged, in the defense's view, wrongly, with conspiracies related to a contested election. Never happened before. It is also the first time that a president has been charged for conduct committed while in office, and the first time that a leading presidential candidate has been charged in the middle of a campaign by his opponent's administration. All true. Factually. As a result, defense counsel must research and address issues of extreme constitutional import that require careful analysis and briefing. And despite due diligence, counsel requests additional time to address these complex and novel legal questions and to ensure that they are properly placed before the court, because, Judge, you want everybody to have a fair trial, don't you? We have due process in this country, don't we? You don't want to stop his attorney from being an effective assistance of counsel. This additional time, therefore, will conserve judicial resources by providing defense counsel the necessary time to assist the court in fully understanding these novel issues. Judge, we're going to help you. If you allow us to brief draft this now, then when it comes time for argument, we'll be able to present it much more competently. You know, it's like when you're painting. Painting can be a big pain in the butt if you don't prep right. If you prep the room and you do it well, painting's pretty quick and easy. But it's in the prep time, Judge. So we got to prep this whole thing out. Then when it's time to do the painting, we're all just going to grab a couple of rollers, boom, and paint the whole thing up. But let us tape the room off. We need 60 days to do it. It will allow counsel the necessary time to ensure that all questions are fully researched, fully examined, and fully briefed. They say, Your Honor, at the outset of this case, the court requested that the parties propose a trial date estimating the time required for trial. And we submitted extensive briefing on the respective trial date proposals. At the hearing, though, the court and the parties focused on their respective views about when trial was appropriate. And at the conclusion of the hearing, Judge Yu announced that your decision was to set trial for March 4th, 2024. Immediately, basically. But Judge Yu did not hear argument about other deadlines. Instead, the court indicated that they would just issue an order and schedule a bunch of the other stuff, pretrial matters, motions, deadlines, status hearings, whatever. So the judge basically said, we'll backfill the dates. I want trial on March 4th. Why? Because March 5th is Super Tuesday, the day before all of the primaries in this entire country. So as people are going to go in to vote on March 5th, Trump's trial for January 6th will have started on March 4th. If you think that's coincidence, I mean, you know, amazing. And she did it, right? And then she said, once that date is anchored in there, so I can cause maximum damage to the Republican Party, we'll just backfill the dates and just schedule them whenever because it doesn't even matter, right? She said, what do I care about motions? The court advised, however, that its initial deadlines would not be set in stone, but if the parties had conflicts, we could alter them. They say, Your Honor, that's pretty sensible. It's going to allow the parties the opportunity to assess their potential motions, including how much research and drafting time it would take to prepare all the stuff. And they say, Your Honor, good news. We have had time to do this analysis. And Trump's defense now advises that it requires an extension. And we have to finalize several of our expected motions, including motions to dismiss this case related to executive immunity. And I know some of these cases have felt like they're a little bit slow, right? Where are these motions at? They're coming, right? They're all coming. Failure to state a claim, improper conduct by special counsel during a grand jury process in charging decisions. Subpoenas are going out. Motions to compel discovery, etc., right? And that etc. is a monster list, all right? So they're gearing up for it. But all of this is just foundational stuff that's working out. And every time they ask for an extension, I love that they're doing this, just to zoom out for a minute, because the judge is going to deny it or deny to some extent some of these motions. I don't think she's going to come back and say 60 days, 60 days, 60 days. She'll come back, okay, how about 2 weeks? How about 30 days? And every time they do that, Trump is basically anchoring in that you are causing us to be ineffective, literally. There's no way we can read 10 Washington monuments of documents. There's no way we can prepare all these pretrial motions. How can we prepare a motion to dismiss the case if we don't know what the evidence is upon which to base our motion? So they're forcing the judge to deny them due process, essentially. So each of these motions will be extensive, no doubt about it. You better believe it. And although counsel has been working diligently to meet the existing motion deadline that you set kind of haphazardly when you scheduled your trial very early, it is now clear that President Trump will require this requested extension to fully address the complex questions raised by the unique legal issues in this case. Additionally, Trump believes that his pretrial motions will be more efficiently and appropriately considered sequentially and on a rolling basis. And all motions have thus far been considered, as they all have, rather than a single burst before an arbitrary motion deadline. So let us submit one, we'll have a reply and a response, and we'll do it again. But we don't need to batch them all together and drop like 5 motions on one day. In this regard, Trump anticipates filing certain motions in advance of this and not waiting until the last day. So this extension would provide additional time that would benefit everybody. In other words, by postponing this, giving us 60 days, you're not actually going to have to wait 60 days. We're going to start dropping these things, but just sequentially. So you can start reviewing. Court, you can do your due diligence, and so can the prosecutor. Finally, Trump's defense has begun the process of reviewing vast amounts of discovery in this case, which is now, 13 million pages of documents. 13 million. And I don't know how many Washington monuments that is, okay? They helped us with the math last time, but it's more than last time. We might be 12, 15 Washington monuments. I don't know how many million per monument. Somebody could have to do the conversion because I can't math. While operating under an unprecedented trial setting mere months from the time of the indictment, 13 million pages. How is that due process? The government had time to read all of those. That's why they put them in their discovery file. files. Why doesn't the defense have the same amount of time? This is a time-consuming task requiring considerable attention, Judge Chutkan, which diverts substantial resources from motion practice because we have to sit there and read War and Peace 25 times a week. Defense counsel needs the time necessary to review this discovery and assess the potential import about the various motions we intend to file. We're unlikely to have even made a small dent in this review by the currently scheduled pretrial motions deadline. How many hundreds of thousands of pages can they get done by October 9th? Not many. An additional 60 days will enable defense counsel to review larger segments of the provided discovery, request additional discovery from the prosecution because Jack Smith is going to deliver a wheelbarrow, right? He's going to just dump it on their desk and they're going to say, okay, we're going to go through it, but we're going to need 5 more wheelbarrows because your documents reference that guy and that guy and that guy and that guy, and you conveniently left all that crap out. Thanks, Jack, but go get it. These tasks, we also have to address matters relating to confidential and classified documents. These go to the heart of Trump's constitutional rights, which nobody cares about anymore, except here, to due process and effective assistance of counsel. We can't do our job if we can't do our job. The reasonable adjournment here would be consistent with a fair and just trial for President Trump, objectives that the court says it believes in, while not prejudicing the prosecution in any way. And they give us some arguments, right? They say here, Jack Smith would not be harmed at all. It would not affect any other deadlines. The case would still be on trial. I'm not asking for a removal of the trial date, but that's going to come because they haven't been harmed enough. All they're asking for is just a couple deadlines, extensions. And then when they have, I don't know, 11 million pages of outstanding discovery, the continuance of the trial motion will be coming. The prosecution would have equal time to file pretrial motions, so they'll get 60 days too, including those that are going to be complex, right? So presidential immunity issues and other things. The extension would also allow these motions to be filed sequentially rather than at once. And if this extension is granted, it's ordinary order. It's not abnormal. Everybody can still file their motions. This is far from the typical case, okay? Trump is not asking for the entire pretrial period. He just wants a brief extension. And here they say this is not causing the government prejudice at all. The court should strike a proper balance. They notify the judge. The government opposes the motion. Jack Smith and Molly Gaston over there say, sorry, judge, this is an egregious violation. We have a speedy trial. The public has a right. Any response under a standard briefing schedule would be due after the current pretrial motion deadline. And so they say, judge, we've got deadlines coming up. Please set a briefing schedule to hash out this issue. In conclusion, President Trump respectfully requests that the court grant the requested extension and give us until December 8th to file our pretrial motions 60 days out from October 9th. Signed here by John Lauro and Todd Blanche, 2 Trump lawyers representing the president. And so this is just one half of the equation. You can see that they are going to be asking for a lot more time. Now the total number of documents is up to 13 million, which is just insane. And you can do the math on that. They did that in prior motions. It's like reading, I think, War and Peace dozens of times a day per lawyers. You know, we did the math. It was crazy. But it's only one half of this thing because there was another filing from Trump's defense as well. This one is saying we need more time also as a result of classified documents being involved in this case. So it's a similar extension request. And the reason I pause on these, I know these are not like, juicy headline motions, like motions to dismiss and motions to preclude or whatever. This is timing and technical motions. But this is going to be where a lot of this, I think, is made, where the egregious violations are made. Trump not having enough time, his counsel not being able to defend him, all of those are due process violations. And the judge is going to really be driving this bus hard to get us to trial on March 4th. They do not want that date to move. And it's basically, in my opinion, it's impossible for Trump's defense to provide him an adequate defense by that date. It's impossible. But 13 million documents, you can just do the math on it. You need 100 lawyers to read all the documents 24 hours a day for months, right? You just can't do it. So every time they file one of these, it's just like a little speed bump in the process. You get enough speed bumps on the road and it really can deviate the whole experience for the government. And it provides every one of those speed bumps, is really a basis for appeal. Every time the judge denies Trump the ability to actually read the evidence, he has a new argument. So here, 10 pages. This one is now involved the classified documents. They say, judge, again, we're seeking a fair opportunity. We just want a fair shake at this. We want reasonable adversary proceedings that can happen here. They say, as you know, CIPA authorizes the court to provide protective orders, allowing prosecutors to delete otherwise discoverable classified materials. So if Trump wants something that is in this batch, they can say, oh, it's classified, I delete it. You don't get access to that because it's deleted. As of today, Jack Smith's office has not disclosed to Trump or defense counsel the type of relief it is seeking or the types of documents that are at issue here. So we want to know what they've got, basically. The standard here says that Trump cannot fully develop his defenses until after we've had an opportunity to review the discovery. For the first time yesterday, Trump's defense says, cleared counsel for Trump, very first time, was permitted to review classified discovery that was provided by Jack Smith in this case. Just got it. And it is now at the end of September, and they are racing to trial in March. Our review was brief and preliminary. We got to see some of it. But it's clear that President Trump is entitled to additional materials that are possessed by the U.S. intelligence community and other executive branch actors. They want to delete this stuff. They don't want us to see it. He says, we're going to request from that office, and if necessary, we're going to go get it. We're going to provide motions to compel and other procedures to go get what they have. They want to delete it from their batch, but we're going to go get it anyways. However, the court information security officer has informed us that restrictions on one of the central documents in the office's classified production currently preclude us from writing to the court or the office about the document's substance in connection with these applications. We do not know when those limitations will be addressed. So they say, Judge, we have identified a piece of paper, a document that we want badly. They say that they're going to delete it from evidence so that we don't get access to it. That's fine if they're entitled to do that. We're going to go through other places to get it, intelligence community and other executive branches. But we can't even bring this up with you, okay? We can't even talk about this document that we're going to talk to you about, or we want to talk to you about, because there are restrictions on talking about the document. So we can't even tell you about we can't mention or talk about the document in our request to you. So we're letting you know. It also appears that other classified material exists for several witnesses, including, but not limited to, classified emails that witnesses in this case exchanged around the time of the events in question, January 6th. Jack Smith's office did not include those classified materials in its first production of classified discovery. In other words, Trump's defense has identified classified information that is probably pretty damning to Jack Smith. Jack Smith is not including those, and they're saying, Judge, classified witness-related materials will likely require litigation, and we're going to fight over this. In other words, they're not giving us the stuff that we're asking for. We know it's there. We're going to go get it somewhere else. They're not disclosing it. And we can't tell you what's in it because the rules say we can't talk about classified documents. So therefore, Trump objects to ex parte proceedings. So the government has been sending little love letters over to Judge Chutkan and saying, this is why we need protective orders. Trump can't get access to this stuff. Trump can't talk about this stuff. Nobody can see it. Protect this case under CIPA. But Trump is saying, no, you can't do that. No secret love letters, nothing ex parte, nothing happening without the other side. You got to go through everybody. They say, yeah, the law says that there is discretion by the court to authorize some aspects of various motions to be filed ex parte, which means the government is sending the motion only to the judge and not copying Trump on it, which you're supposed to do. General motion practice, when you file, you notify the other side. That's why when we talk about other motions, we say the other side objects to it, or the other side takes no position on it, or the other side is in agreement with it. And then the judge doesn't have to think about it, right? Oh, they agree? Perfect. I also agree? Granted. But here they're just bypassing Trump. They don't want Trump to see what's in it. So Trump says, I object to this ex parte proceeding. No little love sessions between the judge and the DOJ. It is not a foregone conclusion that ex parte proceedings are appropriate. We can't have that. But the special counsel say that they object to our request to brief this subject. So they're just saying, Judge, you can have the ability to schedule ex parte proceedings. We know you can, but we're telling you why you shouldn't in this case. Can we please submit a brief on this? Just, that's it. Can we please provide a brief to explain why we don't think you should do it that way? Government opposes. So they say Trump objects to unjustified and unnecessary sealing. Why is everything ex parte? Why is everything sealed? If they want Trump to be prosecuted openly and in public, if he really insurrected America, shouldn't we all see it? So Trump's defense says, Your Honor, to facilitate the appropriate adversarial process and to respect the public's right of access to these proceedings, this court should order Jack Smith to file publicly a redacted version of his CIPA submission. What is he trying to protect? What is he trying to keep us from getting? Why is he going to you ex parte? Put it on the docket so we can all see it. And 2, order Jack Smith to write a memorandum of law with argument and authorities about the basis for the redactions so that President Trump can address those contentions in his other submissions. If they're going to be sending these secret love letters to the judge, post them and make him justify why it needs to be redacted. Now, of course, Jack Smith objects to this request because he would rather have these secret conversations with the judge, and they don't want the public seeing any of this. Although we recognize that some aspects of CIPA do likely contain classified information, no doubt, I'm sure it does, there's no basis for the special counsel to file its entire thing ex parte. Just file a part of it. You can file it on the docket, but let's leave the redactions in rather than just not even allowing Trump to see any of it at all. They give us a bunch of rules here, and they say here it's strange credulity for Jack Smith. We don't believe him to suggest that it's unclassified arguments, right? Things that are unclassified, portions of the whole document, other things like citations to legal authority or any proposed orders that you're going to be ordering on us. Why does that have to be hidden from Trump and the public? It strains credulity. In addition to Trump's due process rights, open access principles under the First Amendment and at common law require a very different course for a CIPA filing that is obviously a very important judicial record. Special counsel should be required to file a public version of this motion and justify any redactions so that Trump and the public have an opportunity to respond. What's so hard about that? Why can't we just see what they're doing? They keep telling us that it's all America needs to know, right? I think even Adam Schiff's like, we need to have cameras in the courtrooms. Fine, we're fine with that. How about you unclassify, unseal, and stop your ex parte secret messages? They say President Trump is going to seek a hearing on this submission. So when Jack Smith submits his secret love letter, they say to the extent the court authorizes Jack Smith to send this in secret, in whole or part, Trump is now respectfully requesting an opportunity for an ex parte proceeding to discuss our theories, which is great. Judge, if you're going to grant them secret meetings, we want our secret meeting. The special counsel's office does not object to such a hearing, but it contends it has to take place in the next 2 weeks because they want to go fast. But that timeline is not appropriate, Judge, and we request the court refrain from setting this deadline until after Trump's objections, after they've already been addressed. Why is this not appropriate in the next 2 weeks? Couple reasons, Your Honor. 1, 2 members of Trump's defense team have not even obtained clearances yet, and they're unable to even look at the classified discovery. And you've also created a compressed schedule because Jack Smith requested it. We've got trial coming up in March. Trump's Sixth Amendment rights require all lawyers to be in a position to review the discovery, and you have not gotten our people certified. Second, Jack Smith's office is not in compliance with its discovery obligations with respect to the classified materials. So Trump cannot plan his defense in time. In order for Jack Smith to comply with these obligations, they've got to get all their disclosures done. Bunch of rules. Now, third, as noted above, in light of restrictions on one of the central documents in the classified discovery, we are presently, Trump's team, foreclosed from making applications to their office related to the substance of the document. Okay, we want one of these central documents in the classified discovery. We can't even talk about it. Thus, we anticipate transmitting discovery requests and motions to compel, but we're not in a position to pursue those mechanisms because we can't see it. We can't talk about it. So, Your Honor, in other words, we're going to be filing a bunch of additional stuff, but we can't do it now because of the rules. So, under these circumstances, even if the restricted handling issue is addressed promptly, like our attorneys get certified, the 2-week deadline proposed by Jack Smith is not reasonable. It's not an efficient use of judicial resources. There is no fair reason to move so quickly on this. And if the court does take the course urged by Jack Smith, subsequent disclosures, if you make us go fast on this, we might have to revise our defense strategy, which again would cause us to have to go back and revisit other things. So for those reasons, do not set deadlines until after Trump has made and reviewed the files. They say, finally, President Trump respectfully requests the deadline be adjourned 3 weeks. President Trump expects to include information from classified discovery in his notices, so Trump needs to review things before he's ultimately able to respond to them and file them, and it would be inefficient to do things backwards. So, therefore, in conclusion, they say the court should order Jack Smith to file a redacted version of its motion on online on the court docket. Let us all see it. And if anything is redacted, he should be able to justify it. Refrain from addressing the CIPA stuff until Trump has had an opportunity to file his objections and make any ex parte submissions of his own, and then adjourn this for 3 weeks so that everybody comply with disclosure obligations. Everybody on the defense team. Signed by Todd Blanche. And this is good stuff. Coming from Blanche Law, New York counsel for President Trump. This is good practice. I mean, you can see how technical this is. They're making all of the good arguments. There's 4 of them here, I think 5 of them. And every one of these, the judge is probably going to reject. I'm going to guess she's just keep siding with the prosecution. And I'm not sure that we're going to see, these documents be posted on the public docket at all. But the point is, these are each speed bumps. And every time the judge comes back and we think it looks like we're getting an adverse ruling against Trump, every one of these arguments is going to form the basis of an appellate argument to say that they were denied due process. They could not act as effective lawyers because they couldn't do their jobs. They had no time. They had no resources. They didn't even have the actual files. Like, they couldn't even read the classified documents. And they can't even talk about the documents to make their arguments. It shatters their legitimacy. Every time the judge rules adversely, and I'm sure there will be more of these, it is another indicator that this whole prosecution is just illegitimate. And my friends, we will continue to cover this. I hope that you join us. Thank you for going to robertgovea.com to sign up for our daily newsletter. In case you miss anything here, you can get the daily reports delivered to your inbox, and we'll see you right back here on the next one.